The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. Welcome to the 5th edition.
Are you counting?
Of Ask a Lawyer. I have now survived a lot of TV shows did not make 5 episodes.
There you go.
So I consider myself a success. So, welcome. I'm Stuart Address, and we're going to start off today with, I think, a little bit of humor before we go into what is a very relevant topic, but can be a little bit dry. I'll try not to make it dry, and that's wage and hour law, overtime, minimum wage, whether you're all being paid properly or deserve more money. So I'm going to say welcome, potential litigants. Are you a potential plaintiff? Want to sue somebody? Do you think you might be sued and you're a potential defendant? Well, here's your opportunity to give a call and maybe see what's going on. You give us a call, 340-1590, and I'll be happy to try to answer your questions. So the first question I'm going to ask is to my wonderful producer.
Uh-oh.
So let me ask you a question. I mean, I'm a radio neophyte. As a producer, you get paid for this gig?
I do.
You do?
Uh-huh.
You ever put in more than 40 hours?
No. It's
No?
radio. We you know.
If you did, you think
know.
you'd be entitled to overtime or not?
Probably not.
Really, why not?
Because usually in broadcasting, your salary.
Oh, my little...
Now, I do. I have to say, I was in that situation. I was, quote, middle management for the big company who's in big trouble now, but this was years ago. I felt as though I worked morning, noon, and night.
Probably did.
And I did work more hours than the 40 hours a week, but the job needed to be done.
Well, let me tell you
There
something.
was no overtime, let me tell you.
As I think I mentioned a couple episodes ago, there are 3 exemptions that account for more than 90% of all overtime cases. Executive, administrative, and managerial. And then there are probably another 100 or 1,000 exemptions that come up once in a blue moon, some more often than others. You ever heard of the journalistic exemption?
No.
Well, there is a journalistic exemption. And basically what it provides is that if you're an ordinary folk and you're doing ordinary work, you're going to get overtime. If you are involved in activities that require creativity, innovation, then you may be subject to the creative professionals exemption, and you may not be entitled to overtime.
This is radio. I don't know that anybody would ever admit that we're creative.
So let me, as they say, dumb it down a little bit. Yeah. If you are an on-air personality in radio or television, you don't get overtime.
Right.
You're exempt.
Okay.
So since you keep talking to me during all these shows, you are exempt.
Okay.
Let's keep that in mind. Now, maybe, I'm not saying
maybe I
should.
Quit talk. No.
I enjoy the repartee, but maybe if you were quiet as a mouse,
okay,
you might be entitled to overtime.
Okay, then
maybe
would
not.
I be more of an engineer type?
Probably. All right, so that's our little entry into wage and hour for journalists, the journalistic exemption and the creative professionals exemption. Now, I don't know if you folks like it. I know everybody is always laughing at lawyers and making jokes about lawyers.
Well, there's a lot of good lawyer jokes.
Well, there are, and I'm going to give us some.
Okay.
But I'm not just going to give us jokes. I'm going to start off the show, give a couple minutes, and I'm going to read to you some questions that were actually asked at trials.
Okay.
These are lawyers asking questions at trials. And let's just see how smart the average bear is. I'm going to take my glasses off a little bit. Lawyer, did you blow your horn or anything? Witness, after the accident? Lawyer, before the accident. Witness, sure. I played for 10 years. I even went to school for it. Okay. Lawyer, doctor, How many autopsies have you performed on dead people? Witness. All my autopsies are performed on dead people.
Ba-dum-bum.
Ba-dum-bum. Most of these are ba-dum-bum. I'm just going to give you some of the good ones. Lawyer, do you recall the time that you examined the body? Witness. The autopsy started around 8:30 p.m. Lawyer. And Mr. Johnson was dead at the time? Witness. No. He was sitting up on the table wondering why I was doing an autopsy. Let's see. Even I just chuckled at this one. Lawyer. Doctor, before you performed the autopsy, did you check for a pulse? No. Did you check for blood pressure? No. Did you check for breathing? No. So then is it possible that the patient was alive when you began the autopsy? No. How can you be so sure, doctor? Because his brain was sitting on my desk in a jar. Lawyer. But could the patient still have been alive nevertheless? Witness. Is it possible that he could have been alive and... It is possible... I don't want to screw up the punchline now. Witness. It is possible that he could have been alive and practicing law somewhere. Okay. Lawyer, how was your first marriage terminated? So we do family law too. Witness, by death. Lawyer, and by whose death was it terminated? Just a few more.
Yeah, establish the facts, right?
That's right.
Really have
These
to
are
establish
lawyers that go
the
a little bit overboard and trying to make sure the record is protected.
Yes.
Lawyer, what is your date of birth? July 15th. What year? Every year. Lawyer, how many times have you committed suicide? Witness, is that a question? Here's a cute one. Lawyer, trooper, when you stopped the defendant, were your red and blue lights flashing? Yes. Did the defendant say anything when she got out of her car? Yes, sir. What did she say? She said, what disco am I at? I guess that person's going away for DUI.
Yeah. Forgot they left the club.
Lawyer, you say the stairs went down to the basement. Yes. And those stairs, did they go up also?
Wow.
I'll have a comment at the end of another couple. Lawyer, she had 3 children, right? Yes. How many were boys? None. How many were girls? And let's finish up with, let's see. Lawyer, did he kill you? Witness, excuse me? Counselor, can you repeat that question? All right, so, I don't know. I find these things amusing. Folks, I also would say, just like in any profession, I don't care whether you're a plumber, you're an electrician, you're a doctor, you're a lawyer. There are the good, the bad, the ugly, and the pretty darn good, and then there are the exceptional. I'll tell you, I won't give any names, but I'll give a plug. I had a endocrinologist for a number of years, a long number of years. And I thought, I really liked him, and I had faith in him, and I thought he was really good, and I think he did a decent job. But he retired recently, and I ended up having to get a new endocrinologist, and I went to Cleveland Clinic, and I got this new doctor. I learned the difference between good and superstar. It is really, I think in any occupation, in any profession, there are those differences. And sometimes you don't know what you got until you try somebody else. But,
So was your new doctor the superstar?
My new doctor was the superstar.
Okay. Good.
Absolutely. My goodness. I would give you her name, but I won't because I don't think it's appropriate on the air. But I will say Cleveland Clinic does have excellent doctors. All righty. Now let me get these glasses back on. And we can move into, let's talk a little bit about wage and hour law.
Okay.
Now we've had our jollies. Okay. I think I mentioned a few shows ago when we sort of had the aborted attempt at starting this topic that there are exempt and non-exempt employees. Exempt employees are exempt from the Fair Labor Standards Act, the federal statute that governs the requirement of an employer to pay minimum wage and overtime for hours over 40. So if you are properly exempt, you get a salary, and that's it. Okay? You work 90 hours, you get that salary.
Mm-hmm.
You work 20 hours, you get that salary. Your boss doesn't like that you work 20 hours for that salary, you get fired. But you get what you get and you work what you work.
Mm-hmm.
And the idea is that you work the hours necessary to perform the job.
Right.
And I guess if you do a good job, maybe you'll get a raise, but it's not going to be an hourly pay or overtime pay.
Mm-hmm.
Okay? So then we have to figure out, of course, the key question. We get a lot of calls in my office on this. And the key thing that, my paralegal, when she's doing that initial conversation, I think we have a question. I always love how they come in mid-sentence. But then again, I don't stop talking, so that's probably why. I think we have Glenn on line 1. Go ahead, Glenn.
Hi, nice to talk to you.
Good to talk to you, too.
I'm calling actually for a friend of mine. She's her English is not so great.
Okay.
She works in a salon, and she works on a commission basis.
That's right.
She terminated her job a few weeks back, and she was not paid for 4 or 5 different jobs that she did. And the owner of the salon refuses to pay her. She says that one job she didn't do right, and it had to be done over, so she didn't pay her for that job, and a few other jobs that she did.
Okay.
That she just didn't pay her.
Well, I would say she probably needs to go to small claims court. I suspect that the amount that she believes is owed is less than $5,000, right?
Yeah, it's
All right.
actually less than 500.
If she's a commissioned employee, I assume also, because salon industry, was she an independent contractor or an employee? Do you know?
Independent.
Okay. I think what she needs to do, maybe before she goes to small claims court, is it may be a good idea, and I understand her English isn't well, so maybe somebody like you may be able to help, is a very short letter to the employer, sent either fax or email or certified, something that proves it was really sent.
Yes.
Saying, I'm entitled to be paid the commission for the jobs I performed. If you have an issue over the quality of the work I did, you're certainly entitled to fire me, but you still have to pay me. You can't just decide not to pay me. And
right.
and say, if you don't pay me, I'm going to take you to court, and let's see what happens. A lot of times employers will just, either they'll pay the amount due or they'll negotiate the amount that's due. If not, small claims court is a relatively simple process. It really is. Most people handle it on their own. Now, I do understand that, she has an issue with English. Somebody can assist her, and they don't have to be a lawyer. In small claims court, you don't need to be a lawyer to help somebody.
Okay.
So there is a small claims packet that the clerk of every court has. It's even online. It's really what's called, it's a statement of claim, and it's a pretrial order that you sort of fill in the blanks, and then the court fills in a date. And you fill that paperwork out, you pay what is a relatively nominal filing fee in small claims court.
Mm-hmm.
And then you file it. Both you and the other party get something from the clerk that now has the pretrial order filled out and has a date. And on that date, you go in. If both of you show up, they give you over to an attorney who's donated his time to try to help you mediate. And they basically sit around a conference table, and the mediator tries to get the two parties to agree. If they do, wonderful. You go back before the judge. You announce you had a settlement. It gets memorialized. And then if somebody doesn't live up to it again, you come back. But if you don't have a settlement at the mediation, you come back into the courtroom. You tell the judge, we didn't reach an agreement. And the judge allows you to leave. And then you get another notice giving you a trial date.
I see.
So that is really the procedure. And trials in small claims court, unless it's something really exceptional, they're 15-minute deals. It's you say your part, the other side says their part, If there are any documents, the judge looks at them, and then since civil cases are decided based upon a preponderance of the evidence, which is sort of like 50% and a feather, it really comes down to, I'm the judge, who do I believe? And that's who won by a preponderance of the evidence.
Kind of like Judge Judy.
That's right. Although I think she sort of jumps the gun quite a bit. The judge you'll find in the courtroom will tend to listen to you a little bit more than Judge Judy.
Okay. All right. I thank you very much.
You're very welcome.
Appreciate it.
Take care.
Bye-bye.
Bye-bye.
Well, his question brings up two other scenarios. The independent contractor situation,
Okay.
and then being paid by commission only.
Okay. Let's talk about those two, and maybe that'll take the rest of the hour. Who knows? Okay. Oh my goodness, that could be a whole nother segment. Let's start with the second one first. Let's start with the commissioned employee.
Mm-hmm.
There are positions where you are legitimately entitled to be paid based upon commission. There are a whole varied number of them. If somebody calls me and says, I'm paid solely on commission, then I have to go look at my little testy, list and do a little, finger work on the computer and find out whether it's kosher. If you're paid by commission, then there really is not, if you're an employee, you still have to get the minimum wage. If you're an independent contractor, you don't.
Well, an independent contractor, the way that I understand that, you are setting your own hours.
That's one of 10 factors. Depending upon the court you listen to. It's one of 10 factors, one of 7 factors. The Department of Labor has a list of factors for what distinguishes an employee from an independent contractor. Mm-hmm. The IRS has a list of factors, and they're not the same. Different courts have a list of factors. Our court, for federal purposes, is here either the Southern District of Florida or the 11th Circuit Court of Appeals. The 11th Circuit Court of Appeals, what they say is mandatory precedent for all our federal district courts. And Southern District of Florida judge says something. Another Southern District of Florida judge doesn't have to listen to it, probably will. All right. So when you look at all these different factors, whether they're 6, 8, 10, whatever, you're right. One of the factors boils down to, do you get to set your own hours? But then there are other factors. Do you control the way you perform the job, or are you supervised? Do you perform what work you choose to do, or are you told what work to do? Are you required to have your own tools, or are the tools provided for you? So what we tend to do when this situation comes up in our office is we look at, one of the factors list, whether it's the IRS or whatever we pull out, and we start going down the list with the prospective client. Mm-hmm. And what the law says is no one factor determines the outcome. It's the predominance of the factors. If more of the factors argue in favor of you're an independent contractor, then you're legitimately an independent contractor, and that has benefits and drawbacks, particularly in wage and hour law. Mm-hmm. Mm-hmm. If the majority of the factors argue in favor of you being an employee and your employer is insisting on paying you and has been paying you as an independent contractor so they can get away with not paying the employer's share of Medicare and Social Security taxes.
Or even workers' compensation.
Exactly. Mm-hmm. Then you have a claim. And it's interesting, if you believe you're an employee and you're being classified as an independent contractor by, I'll keep calling it the employer, a lot of people go to an attorney, and that's great, we can help. But there's another way to do it. If you go onto the IRS website, which probably sends fear through everybody's hearts, you go on irs.gov, there is a form, a simple form that you can fill out that explains why you believe you're an employee as opposed to an independent contractor. Once you file that form with the IRS sends a letter to your employer. We all know how we love to get letters from the IRS. And the IRS letter to the employer doesn't disclose your name.
Okay.
But says a complaint has been filed. Please give us all information as to all people you have classified as employees, all people you have classified as independent contractors.
And they do that because you may, as the employee or employer, you may owe them money.
Exactly.
Which is why they would do it.
It may not be just this one person you're doing it to.
Sure.
So if the IRS then determines that you were improperly classified and you should have been an employee, you could now file another form to get a refund of the excess Medicare and Social Security taxes that you've been paying, because you've been paying both the employee and the employer's share.
Mm-hmm.
So, that's not insignificant. The Social Security taxes are 6.2% of the wages, and the Medicare taxes are 1.45% of the wages. So that's 7.65 if I'm not stupid. That's not insignificant. So you go get your refund, and then the IRS says to the employer, pay up, and by the way, here are the penalties, here's the interest, don't do it again.
Mm-hmm.
And now that employer's tax returns are probably going to be red flagged for the next few years with the IRS.
Wow.
Sometimes when somebody comes to us, depending upon what the situation is, we may either send a letter to the employer and see if we can resolve it quickly, or we may help the person, direct them to the IRS form or give them the form and say, this is the way you want to do it. And if it doesn't work, give us a call back, and then, maybe we can threaten a lawsuit. So that is independent contractor versus employee. I will tell you that I have found more frequently than I would like to believe that people are misclassified as independent contractors when they are really employees.
Mm-hmm. But it's a situation where, do you want to work here?
Well, you're right. And that is always, look, that's why when an employer says, I'm cutting your commission, you can leave, but do you want to work there?
Mm-hmm.
If an employer improperly says, I'm cutting your commissions for the last 6-month period, you can't do that. You can't do it retroactively.
Mm-hmm.
An employer can change the terms and conditions of your employment prospectively
Going
forward, but not going backwards. Okay, I think we have another call. And
Hang 1 second. There we go.
okay. We have, Bulldog on line 3. How you doing, Bulldog?
Hey, how are you doing, Stuart?
I'm doing fine.
Hi, Veronica.
Hey, Bulldog.
I have maybe a little additional thing that I want you to explain to people on the difference between going, 1099 versus W-2.
Right, independent contractor versus employee, right.
Well, no, a W-2 is not technically an employee, because then a W-2 is still a contractor. It's a W-2 contractor, and yet in that way they can write the contract into where you are limited to 40 hours a week and you do not have access to medical benefits.
I'll be honest, Bulldog, I'm not familiar with what you're describing. I've honestly never heard of a W-2 individual being classified as a contractor of any type. Usually when you're first hired and the employer has to go through the various verification forms, the I-9, the immigration form.
Oh, right,
have
right.
you fill out your W-2.
Yeah, I've done it 1,000 times.
Usually that's you're an employee.
But what you are then is you are a employee technically of a consulting company, which then puts you on a job.
Okay, you're talking about somebody that assigns you to jobs. I think I know what you're talking. You're talking about you're working for a company, and the company, let's say, hires out its labor and says, okay, you're going to go work at Lowe's for the next month.
Right.
Okay. You want to know something?
Like that.
Under the law, they're both employers. They're joint employers. And that has a lot of other consequences. I have a mediation this afternoon after this show where the issue of joint employers is going to come up as to who's obligated to pay any overtime or minimum wage violations, assuming any actually occurred.
But then again, they can write in your contract that you're limited to 40 hours a week.
They can write that in your contract, but let me tell you, the law is really very clear on that. If you go beyond the 40, they've got to pay you time and a half. If they want to fire you because they told you do not go over 40, or do not go over 40 without our written permission, that's a perfectly legitimate term of your contract.
Oh,
but
good.
if you work it, they've got to pay it to you.
And you lead me to my next subject.
All right.
At will state.
Okay.
Versus not at will, and what do you do for remediation in those cases?
Well,
or is there any path to it?
Oh, that's a whole other topic, and I'll give you a short answer, and it'll probably be a topic I'm going to talk about in a few weeks. As an at-will employee, in Florida in particular, and Florida is probably the worst state to be an at-will employee. People confuse at-will and right to work. And I always get people say, "Are you a right to work state?" And they're really thinking of union issues. We are an at-will state. At-will employment means that your employer can discharge you for no reason at all, for a good reason, a bad reason, a fair reason, an unfair reason, a correct reason, or an incorrect reason. The only prohibition is the employer may not discharge you for an unlawful reason. Now, what's an unlawful reason? It usually falls into 2 or 3 categories. It's because you filed a workers' comp claim, and it's retaliation.
Which happens.
Mm-hmm. Oh, it happens a lot. Because you went out on family and medical leave, and now they're unhappy with you, so they're going to punish you when you come back. Or more commonly, you're being discriminated against, whether it's race, age, gender, national origin, religion. I may have missed one. So you may be an at-will employee, but if your employer has been subjecting you to discrimination, then they can fire you, and then you're going to have a claim under a whole different statute than we're talking about today. You're going to have a claim under Title VII of the Civil Rights Act for either discrimination or for discrimination and retaliation.
Okay, all right. I'll give you a really short example.
Go for it.
I know someone that works in the hospitality business that as soon as Governor Scott said hurricane, evacuate the coastal areas and all that, he left his job to go board up houses and stuff like that, and they fired him for abandonment of work.
Yeah, I had a case similar to that.
And you know, that's just one of those, and they looked at him and said, at will state, nothing we can do.
And that's absolutely true. There are, first of all, at this point, I think it's 48 or 49 states are at-will states. It used to be 46, and they've been dwindling. But there's a difference in at-will in different states. And the fundamental difference is this. Some states say you're an at-will employee except for public policy reasons. If the employer terminates you and it's contrary to public policy, you have an argument. Some states say you're an at-will employee except for public policy reasons, and the statute enumerates 1, 2, 3, 4, whatever other reasons. Florida says you're an at-will employee, period. As my father used to like to say, end of conversation.
Right.
So the only exception is what's provided for either in federal law or Florida also has the Florida Civil Rights Act. It sort of piggybacks on the state one. The only difference is there are slight differences in the damages that are available. So when lawyers file these cases, we tend to file them both under Title VII of the Civil Rights Act, which is federal, and then we also throw in the state Civil Rights Act claim so that we can get all the different damages that are available under both the federal and the state statute.
Well, sir, and I hate to throw you off topic like that. It just came up in
okay.
Conversation, but I look forward to, a couple weeks from now when you bring up that topic.
Yes,
and discuss
it's
maybe
definitely
in more detail.
It's definitely on the drawing board, because I will tell you, in my practice alone, probably a quarter of the calls and a quarter of my cases at any given time are Title VII cases. They're discrimination or retaliation cases or sexual harassment cases. So we do quite a bit of Title VII work, and yes, it's going to be it's such a complex topic because there are so many things we could talk about that I want to try to figure out what the best way to do it is in one or two shows where we deal with the issues that the average person may really encounter, as opposed to going through things that nobody's ever going to really have happen to them.
All right. Well, thank you very much for your time, sir.
You are welcome.
Have a great day.
Good to talk to you.
Great.
All right.
340-1590. Any other questions, give us a call.
Sure do. Like answering them. All right. So we were saying that, if you're non-exempt, you got to be paid over 40. Qualifier for exempt, I think we did mention this. You cannot be docked for less than a full day's wage. If you need to be out for a day, your employer can dock you for a full day, even if you're an exempt salaried employer. You need to be out for half a day. If the employer docks you, he's just lost the exemption for that weekly period. If he does it 5, 6, 7, 8 times, he or she has probably lost the exemption forever for you. So they have to be careful. Employers have to be careful how they pay both exempt and non-exempt employees. And very often they use payroll companies. There's a good side to that and a bad side to that. The payroll companies are excellent at making sure that this times this equals this, and the proper taxes are taken out. But if they don't get the proper information from the employer, they may very well dock you because they think that's what they're supposed to do. And the employer is not going to be heard to argue in a court, well, I didn't do it, my payroll company did it, because the payroll company is the agent of the employer.
Now, would you have to have like timesheets and things like that to go hourly versus salary and all of that? Would you have to have those, or like a time clock?
Another excellent question. Going to deal with it this afternoon in my mediation. The Department of Labor, in interpreting the Fair Labor Standards Act and the Act itself, does not require employers to keep time in any specific form. You can use a time clock. You can use Post-it notes. You can do whatever you want. You can use the honor system, which is subject to possible abuse. Whatever you want to do. However, there are certain types of information which the employer must keep for non-exempt employees. By memory, I'm never going to get them all, but essentially they're things like name, date, social security number, classification of the employee, hours worked, however you keep it. You have to have the information. And the Fair Labor Standards Act makes crystal clear the burden is on the employer to have complete and accurate time records. If the employer has not kept complete and accurate time records, there is a consequence. The consequence is the employee is to be believed, whatever their testimony, unless somehow the employer can disprove it and cast doubt upon the credibility of the employee. But the employee comes in and testifies, I work 60 hours a week. And the employer says, that's crazy. You never work more than 40 hours a week. Where are the timesheets? Where's the record of how much, when you were in, when you were out? Employer, no, I don't keep those things. Judge is going to instruct the jury on the law. And the law is, unless you have a reason to find the employee's testimony not credible, you are to assume that it is accurate because of the employer's failure to discharge the burden of maintaining complete and accurate time records. Most part I represent employees when it comes to wage and hour law. There are some times, such as this afternoon, I represent employers. And when I represent employers, always, in the beginning, I'm trying to tell them, as a plaintiff's attorney, let me tell you what we look for when an employee is coming to sue you. And you need to make sure that you dot your I's and cross your T's. And you need to make sure you're properly classifying them because there are penalties for that. Some employers try to do the right thing and it gets screwed up because they're not lawyers. The only benefit they may get from that is possibly when they lose the case, the court won't double the damages. It's called liquidated damages.
Mm-hmm.
Generally, whatever an employee wins gets doubled. It's a penalty. It's like punitive damages, except the statute calls them liquidated damages. The only way to avoid that doubling is if you can really show, not just ignorance, but really show good faith. Like, I called the Department of Labor and I asked the question, and I spoke to Miss Mulcahy on February 5th at 2:27 a.m., really first thing in the morning, and she told me the following, and her identification number is 3496.
Mm-hmm.
Oh, and I got a confirmation number, by the way, and here it is. Well, you tried. If you got the wrong information, you're probably not going to be punished by having to pay the double damages.
Mm-hmm.
But typically, it's double. It's double plus attorney's fees and costs, which is why attorneys like me like taking these cases for plaintiffs.
Well, I could see that it would have to be that way because it could be a very small
Right.
amount of money that this person was suing over, and why would an attorney want to take a case for that?
Well,
Like, how does-
the statutory attorney's fees provision really is the mechanism that Congress put in to sort of give the oomph to attorneys to say, look, it's a small dollar case, but if the employer fights it, the longer they fight it, the more money we're going to give you as attorney's fees.
Mm-hmm.
And there are several statutes like that have statutory attorney's fees written into them. And so attorneys take them even though it may not be a significant dollar case. Very literally.
I would think knowing that, too, if employers know that, then that would be like, let's do this by the book.
That is true, and it's also why when an employer gets a demand letter from a lawyer, even if he goes and gets his own lawyer and checks it out, which is smart, usually these types of cases settle before the lawsuit's filed. The potential exposure to the employer is so significant that sometimes, what I would say to an employer is, I know you believe you're right. From the facts you've given me, I think you are right. Do you want to test that in court in 2 years after going through discovery?
Right, and you got a business to run
Right.
in the meantime,
Or
too.
do you want to make a business decision even though it really sticks in your throat and pay the guy or gal something?
Sure.
And, in some ways, I believe it almost is a legal manner of extortion because employees can take advantage and employers are so fearful of the consequences of losing a wage and hour case. But, generally I'm a plaintiff's attorney and I have just come across way too many instances where employees are mistreated, and I don't mean they're treated bad because the employer curses at them. I mean they're mistreated in the way they're paid. And a lot of people are afraid to say anything. So what the statute provides...
Yeah, I have to say, I know a lot of independent contractors in radio.
So the statute says you can go back 2 years, and if what the employer did was willful, you can go back 3 years. We have Bill on line 2. How you doing, Bill?
Good morning. Thanks for taking my call.
Not a problem. How can I help you?
Well, I'm not sure that this is an area of your expertise, but, it could be family law or it could be tax law.
Okay.
The situation is my father died at age 96 a little over a year ago, and several years prior to his death, his lawyer had drawn up a warranty deed with my brother, sister, and my name as the owners of his property, his house, 3 sheds, and all the contents. Whenever the day he died.
Right.
Okay, so after he died, we filed that with the courts, and now we own the property, but it's in our 3 different names.
Right. So legally you all own it as tenants in common.
As tenants in common. Okay. Well, we would like to sell the property, but I'm a little puzzled as to how we sell that property, and each of us, the 3 entities, pay our own share of the taxes. How do we handle that?
It's a good
Or is there a problem there?
No, there's no problem. There's no problem there. It's a good question.
If you get along really good with your siblings.
It is a tax question, and I honestly don't know the legal mechanism. And as you know, if you get along with the siblings and you all agree you're going to pay 1/3, 1/3, 1/3, that's great. The question is how to pay it and make sure that the IRS realizes, everything's getting paid, but it's being paid by different people. I suspect, and I don't know, if there's any tax folks out there listening, give us a call. I suspect there is probably a form for that situation. It's not an uncommon situation. The more common situation I hear, at least as a litigator, is my brother, my sister, we have this property in our name. I want to sell. My brother wants to sell. My sister says, no way. What can I do? Mm-hmm. That's usually what I hear.
Yeah, we don't have that problem.
I wish I could give you a definitive answer, but I think I even avoided taking a tax class in law school.
Yeah, maybe call one of the big companies that prepares taxes. They might be able to just answer that off the cuff.
They very well may be.
Yeah.
They may be able to direct you to a form that deals with when there are multiple owners of a property as tenants in common. When you sell it, how do you handle it? And, frankly, who probably knows the answer? The title company.
Title, okay. Well, I've also got a call as the lawyer that drew this up, Matt Kim. He may know.
I would hope so if he drew it.
Okay, well, I appreciate it.
All right, sorry I couldn't help you more.
That's fine. Thank you.
Bye-bye. All right, so let's just quickly try to run through the three main exemptions.
Okay.
And then I'll go at the speed of light through a couple others just so people know they exist. The executive exemption requires a few things. Basically, there are three things. It used to be you had to have a salary of at least $455 a week. That changed this year. $913. The idea is to make you pay a higher salary to call a person exempt.
Okay.
So you have to be paid $913 a week. Your primary duty has to be to manage the business or an entity, a sub-entity of the business. And you must regularly direct the work of at least two full-time people.
Okay.
Now, two part-timers equal a full-timer. You can mix around with that.
Mm-hmm.
Also, the last thing is you must have authority to hire or fire,
Mm-hmm.
or your input into hiring and firing must truly be given considerable weight by the employer.
Okay.
If you meet those tests, you're subject to an executive exemption and don't have to be paid overtime. I wonder, frankly, how many employers were careful enough to realize that the requirement for salary changed from $455 to $913. And how many people out there, not just in our listening audience, but in the country, are being paid $500, $600, $700 a week, and the employer thinks they're exempt, they think they're exempt.
And they're being told they're middle management.
And they're not exempt. Right.
Yeah.
The administrative exemption is similar, but different. It's the way law is. You have the same $913 weekly salary requirement. Your primary duty must be the performance of office or non-manual work relating to the operations of the business or its customers. And your primary duty must include the exercise of discretion with matters of significance. So if you can't make your own decisions, if you've got to go to your boss for everything, then you're not going to be subject to the administrative exemption.
Right.
The professional exemption, $913 a week. Your primary duty has to be performing work requiring advanced knowledge. The advanced knowledge has to be in a field of science or learning. And the advanced knowledge must customarily be acquired by specialized education. That gets us into nurses. Sounds like they would qualify for the professional exemption. I mean,
they work really weird hours.
Well, okay, but some of them work 60 hours, Do they have to be paid overtime or are they exempt?
Yeah.
It's interesting, not all nurses are created equally, I've learned.
Well, isn't that true anywhere you go?
Well, there are some that are better than others, but that's not what I'm talking about. If you are an LPN, a licensed practical nurse, then you are not an exempt employee. You do not have the specialized training that would subject you to the professional
Okay.
exemption.
So that degree doesn't get you into
No,
that.
you got to still be
Okay.
paid overtime.
Mm-hmm.
If you're an RN, registered nurse, yes,
Okay.
you get the professional exemption, but here's the but, always a but. Law is a lot of gray. If you're an RN and you're dealing with patients, of course, you're exempt. If you're an RN and you're just dealing with administrative stuff, you're not exempt.
Okay.
Okay, you're not doing what the statute or the exemption requires. You know. So those people, have to look at, it's like being a supervisor. Any type of a nurse who's a supervisor is probably not going to be exempt unless they meet one of the other exemptions.
Okay. Like the weekly.
Executive like they supervise 2 or more people.
Okay.
Yeah, unless they meet
But
the
they would have to be
elements-
making that salary as well then, right?
That's correct.
Okay.
That's correct. Now, I found it interesting. I've had a few calls in the last couple of years that aren't between LPNs and RNs. It's, I do home health care. Seems to be a growing area, particularly
Here in
the
Florida.
Treasure Coast and in Florida.
Yeah.
So, what's the law when you're dealing with, a home health nurse? And not everybody actually has a nursing degree that does home health care. So,
Yeah, a lot of those that take care of you in the hospital don't really have a
That's
degree
true, too.
either anymore. Yeah.
So, an employee generally who performs companionship services in a private home is exempt from the minimum wage and the overtime laws. Companionship, I don't know why I can't say that word. Companionship services means services for the care, the fellowship, the protection of people who, because of advanced age or physical infirmity or mental infirmity, cannot care for themselves. Now, that could include household work, preparing meals, making the bed, things like that. However, you're an RN and you're doing this type of work. And in addition to doing your medical duties, you're doing some of these other household type duties. You could lose, or the employer could lose the exemption and have to pay you overtime if the household component, the companionship services, is more than 20% of what you're doing in a week.
Okay. And that could easily happen.
It very easily could happen.
Yeah.
So really, to keep RNs exempt, you want to be very careful in what you're allowing them to do and what they are doing, because we get back to the central question. You as the employer say, you can't do this, you can't do that, you can't do overtime without permission, you can't eat lunch at your desk. You still got to be paid if you do.
Okay.
It doesn't matter if the employer told you not to do it. Now, there's a consequence to that. The employer can say you're fired, or if you do it again, you're fired. But if you do it, you got to be paid. One of the biggest things that comes...
I have to wonder how many RNs might be doing it independent contractor.
Yeah, well, it's true. Now, one of the biggest things that comes up is lunch. I used to tell my paralegal, you've got to go out for your hour. Because if I get a call and I need something, and I'm lazy, and I yell, Cheryl! And she responds.
And she's on lunch.
During lunch.
Okay.
Her entire hour is now compensable.
Okay. Even if she just answers you.
Yeah. If she does anything work-related
Yeah.
in that hour, she now has to be paid for the whole hour. So really, that's why a lot of employers say you must have your lunch off-site. They are trying to protect themselves from supervisors or whoever else who, because they see you, ask you to do something. Now, my paralegal's been with me for a while. I let her eat lunch in her room with the door closed. And let me tell you, there are still occasions where I go, oops. And I call out for her, and I go, never mind. Because I realize
She's at lunch.
She's here, but she is at lunch. And she has to have that time to herself. I mean, that's part of the law. Let's do, I think, one other exemption while we have time. Let's do computer-related occupations. A lot of people are in those, and we do get calls on that. There is a computer-related occupations exemption. Again, salary, if you're salaried, $9.13 a week. The employee has to be employed as a computer systems analyst, a computer programmer, a software engineer, or some similarly skilled worker in the field of computers. So it can't be just anybody. And that employee's primary duty has to be the application of systems analysis, techniques and procedures, the design, development, documentation, creation of computer systems, or the design, documentation, testing of systems related to how they interact with the employer's business. So calling an IT guy and just having him do something basic doesn't mean that IT guy, especially if they're an in-house employee, is exempt. You have to have somebody that is doing things of this nature to truly qualify for what's called the computer-related occupations exemption. What the Department of Labor has these fact sheets for almost everything. And if you go to the Department of Labor website, dol.gov, you put in the search bar fact sheets, you're going to come up with a list of every fact sheet they have. And the fact sheet on the computer-related occupation says, essentially, it doesn't include employees engaged in the manufacture or the repair of computer hardware or related equipment. It doesn't include employees whose work is highly dependent upon the use of computers and computer software programs, but who aren't primarily engaged in analysis and programming. So, the fact that my paralegal has to use the computer every day, and sometimes I say, can you figure out why that thing won't work? Or can you look at my printer? It's printing way too slow. See if you can figure it out. No.
That doesn't make her IT guy.
Right. It doesn't get her the IT exemption. But in just the little time we have left, I'll tell you one other little tidbit. Probably doesn't apply to everybody out there, but maybe there's some paralegals listening, or some paralegals. This happened in Florida just a few years ago. Paralegals have to be paid overtime. Paralegals that work more than 40 hours a week are subject to overtime. There was a law firm in Stewart who didn't think so and didn't pay overtime to paralegals. And there was a legitimate...
You would think that they would know the
Well, no, there was a legitimate question at that time as to what the law was and whether paralegals fell into another exemption. And, of course, what happens is that paralegal gets fired and goes to a lawyer and decides, well, I'm going to challenge this. And it went to trial. And the determination was, and on appeal, that paralegals are subject to overtime. They're not professionals. Maybe they have a paralegal certificate, but that is not the advanced knowledge that is referenced in the professional exemption. So they too. Now, how do I try to protect against that? How have I suggested a couple of law firms that I've spoken to try to protect against that? I'm sure Cheryl will love this if she's listening. I make her, on her timesheet, sign the timesheet herself, and there's a legend that says, I hereby certify that these are my true hours, all of my hours, that I have not left anything out, I have not been asked to leave anything out, blah, blah, blah. Now, does that mean, I don't want to give her any ideas, does that mean she can never sue me successfully? No, it doesn't. Because she can go in and testify. He told me I couldn't put these hours down.
Right.
And now it's a question of...
But then that's sort of a he said, she said thing.
It's a question of credibility, but I may have the upper hand because of that legend that I made her sign on every timesheet.
Now, we are just about out of time.
So, folks, stay tuned next week, Friday at 10:05 for Ask a Lawyer. My office is in Stewart, Florida. The number is 781-8003. And I'm glad you were listening. I'm glad to take your calls. And that's it, folks. Goodbye.